All right then.
Hey,
So it is July 3rd, 2020. It's 4:15, and this is a special meeting of the members of the State Liquor Authority. Present today, all by phone, are Chairman Bradley. Chairman Bradley, could you just give a shout out so we know you're there?
yes, I'm here.
Commissioner Fan. Commissioner Fan, could you just acknowledge that you're there so the
Yes,
record.
I'm here. Sorry
And then
about that.
Commissioner Ford.
I'm here as well.
All right. There is one item on today's calendar for the record date. This would be item 2020-787C. It is a request by Counsel's Office for a summary suspension of a license regarding serial number Columbia SL 2004653, issued to Lebanon Valley Concessionaires doing business as Lebanon Valley Speedway. And with that, I will turn the mic over to Council Meyerhoff.
Good afternoon, everybody. This is a speedway, a race, an auto raceway located in West Lebanon, New York, 1746 Route 20. We found out this morning, and that's why we've hustled this together, and I'm going to end up reading into the record a bunch of the information that we would ordinarily have given you in hard copy. But we found out this morning an email from the town supervisor in New Lebanon that he had been getting complaints, or she had been getting complaints about the fact that this location was planning to reopen the racetrack for the first time on July 4th and hold an event and have people show up and have a fireworks show. And this is the email we received to the governor's office. I forwarded you an email, and I'm reading now, from a concerned citizen about the speedway opening illegally this weekend. I know last weekend New York State threatened to pull his liquor license, if he opened illegally, and it was not enough, and it was enough to get him not to open. Do you know if the state is getting involved for this coming weekend? He is advertising racing with fans and spectators and a fireworks show. He is also advertising that there is no limit to the number of people they will let in. I keep having concerned residents calling me, and I'd like to know what to tell them. The town is doing our part of enforcement, but he's already said he'll just pay the fines, which is really all the town can impose. It seems the only thing that has stopped him in the past is the threat of pulling his liquor and or food service permit, and I'm wondering if you are in the process of doing that so that I can let residents who are very concerned about big fans coming into our town from out of town this weekend and not wearing masks and not social distancing, please let me know. So upon receiving that email, we checked the website of this location, and sure enough, the event was being advertised, and there was a flag on the internet website that says, for immediate release, on Friday, June 26, 2020, United States District Court Judge Gary Sharp found that the limits placed on outdoor gatherings by Governor Andrew Cuomo of New York were potentially unconstitutional and issued an immediate injunction forbidding the state of New York from enforcing any limitation for outdoor gatherings, providing participants in such gatherings follow social distancing requirements. Racetracks in New York can once again welcome fans into their stands, providing the fans observe social distancing, 6 feet between each adult, and wear masks. Social distancing requirements will at some tracks place limits on total attendance. Welcome back! Exclamation point. So that was posted on the site today, and as I will tell you later, we tried to get them to cancel this event by calling them, and even left a message for their lawyer, which I will get to as well. That if they if they posted on their website by 4 p.m. this afternoon that they were not holding the event, we would not proceed with this request for a summary suspension. That did not happen. As of 4 o'clock, that was still posted on their website. Let me move to why this is a violation of the existing executive orders, which poses a significant threat to public health and safety. Starting with Executive Order 202.47, which extended Executive Order 202.32, there's an express permission that allows racetracks and auto racetracks to open, but only if they do not permit any visitor or spectator into the facility or on premise. That has been the rule since racetracks, auto racetracks, and horse racetracks have been allowed to be reopened. Executive Order 202.32 has been in place for a while and was just recently extended through the current date into July under 202.47. So they're allowed to be open, but no spectators. I suppose much like a lot of sporting events are being now permitted to occur, but not with spectators. Executive Order 202.47 also has a restriction on fireworks. The use of fireworks or dangerous fireworks during the state disaster emergency declared by Executive Order 202 shall also be punishable as a violation of Section 12b(2) of the Public Health Law. So this event would be in violation of that as well. In addition, there is a general executive order on non-essential gatherings of a certain size. This particular licensee is in a region that is in Phase 4 of the pause reopening plans for New York State in the Capital District. That is currently governed by Executive Order 202.45, which restricts non-essential gatherings of individuals to no more than 50 people in regions that have reached Phase 4 of reopening. So for all of those executive orders in place to ensure the protection of health and public safety in connection with the coronavirus pandemic, they're all implicated by this proposed event. We had an investigator call over today and spoke with both the licensee's principal, Howard Commander, and then subsequently the licensee's attorney, Mr. McGuire. And I'm going to read to you, it's short, a couple paragraphs, the report of the SLA investigator, Brian McLean, who spoke with these individuals. And now I'm reading. I spoke with Principal Howard Commander via telephone, and then gives a number. I explained to Mr. Commander that we have been receiving complaints about his advertised July 4th, 2020 event, in which he's advertising racing with fans in attendance and a fireworks show at the conclusion of the event. I explained to Mr. Commander that his venue has not been approved to be open, and certainly not for an event like this. I explained to Mr. Commander that holding this event would be in violation of Governor Cuomo's executive order and that he could be putting his liquor license at risk. Mr. Commander informed me that he believes that according to a lawsuit brought on by the Trump administration, he is able to hold this scheduled event. Mr. Commander informed me that he was told by Congresswoman Stefanik and his attorney Ken McGuire that he can proceed with the event. I again informed Mr. Commander that this would be violating the executive order and his liquor license may be at risk. Mr. Commander politely told me that he is having the event, and if that means that the NYSLA takes his liquor license, then so be it. Mr. Commander asked me for my phone number and informed me that his attorney, Ken McGuire, would be calling me. Mr. McGuire, the attorney, called and left a message which I did return. Mr. McGuire cited the below district memo and order of June 26, 2020. Mr. McGuire stated that this court order prohibits the governor from limiting the numbers of people in attendance, but social distancing must still be adhered to. Mr. McGuire's below brief summary, there's a link to the actual district court memo and order, and then the report from our investigator attaches an email from the lawyer for this licensee that says, Investigator McLean, below is the link to the decision. To summarize my position, when the court says, order the defendants are adjoined and restrained as follows, from enforcing any limitation from outdoor gatherings, provided that participants in such gatherings follow social distancing requirements as set forth in the applicable executive orders and guidance. What the court means, and this is still Mr. McGuire's email, what the court means is no limitations, social distancing accepted. Thanks for your assistance, Ken McGuire, Jr. And then he attaches a link to a June 26th order from a federal district judge. So Mr. McGuire's position to us today was at 1:51 p.m. that this order that a federal district judge executed on June 26th somehow trumped, excuse the pun, trumped the executive orders that the governor has issued that would restrict the event that's being planned for tomorrow. The June 26th order is a order in a case called Reverend Stephen Soos, S-O-O-S, v. Andrew Cuomo. This was reported in the press last week. Two religious organizations, well, I guess Mr. Soos is a reverend, sought to enjoin the restrictions against religious services in the governor's executive orders, specifically religious services, as being violative of the First Amendment right to the free exercise of religion. That case did result in an injunction being issued, but that injunction was issued with respect to religious services and religious services only under the Free Exercise Religion Clause of the First Amendment. That's what the injunction is based on. That's what these plaintiffs were asking for. So what this Mr. McClain is saying is that the language of that order somehow applies to racetracks too, not just religious services, but to racetracks too. That's why he refers us to it. My reading of it is it does not apply to racetracks. It applies to religious services, and only to the restrictions on religious services that are in the executive orders. So the funny thing about it is we've now learned that Mr. McGuire, who this afternoon told us this order applies, even himself did not believe that it applied to racetracks. How do we know this? Because Mr. McGuire sought to intervene in that action yesterday as counsel to the licensee and asked the judge to extend this ruling that was about religious services to apply to racetracks. He would not have done so had he thought that the order as written applied to racetracks. But in any event, the judge already acted on his application. There's a text order online for this case that says, text order only, and now I'm reading, pending is an application for preliminary injunction filed by Kenneth McGuire, an attorney admitted to practice in this court in 1994, who represents no parties to this action. All right, now I'm not reading, I'm just commenting. This is the action that was filed by the Reverend against the governor. So he tried to intervene into that action. It is not clear, and now I'm reading again, it is not at all clear who or what McGuire represents. He purports to seek relief on behalf of, quote, auto racing facilities located and operated in the state of New York, including but not limited to Lebanon Valley Speedway, West Lebanon, New York, ID at 1. McGuire argues that the court's June 26, 2020 memorandum decision and order applies to the interests that he represents, ID at 2 to 4. Among other things, the application is procedurally improper. It was filed by an attorney who represents undisclosed entities that are not parties to this action. It is not compliant with Rule 7.1 of the local rules of practice either. Lastly, the motion is obviously without merit and arguably frivolous. For all of these reasons, the application for a preliminary injunction is denied. It is so ordered, issued by Senior Judge Gary L. Sharp on July 1st, 2020. So, in summary, to summarize what I've just described, because it's a lot of legal jargon, there was an order, an injunction granted on a very limited basis for religious services and the restrictions that relate to religious services. It does not apply to anything outside of religious services based on its own terms. And the lawyer for this licensee, apparently recognizing that, went forward and tried to get it expanded. The judge refused to do so. And notwithstanding all that, this lawyer is now telling us, and apparently his client, that he is free to operate in violation of these executive orders under this order. That is the record, essentially, that we have for you. We have every expectation, since all of our information suggests it, that this licensee intends to ignore executive orders specifically addressed to his type of business that tell him he cannot do what he's doing. And he is going to, whether his liquor license is suspended or not, we expect him to hold this event. But there is no question in our mind, in my office's mind, that this poses a significant and imminent threat to public health, safety, and welfare. This is the very type of event that the state is desperate to avoid having take place. Desperate to do so that we do not end up in the same situation as many states in this country, as we are seeing, with climbing coronavirus statistics at a time when we've actually done a fairly good job of keeping this under control. For that reason, we brought this case to the members and asked that a summary suspension order be issued. If you guys have any questions, I am ready to answer them.
Commissioner Fan, any questions?
Gary, I just want to back up for a second. When you talked about the basis for the violations, the 3 or 4 EOs, the first one was only if there are no spectators, then the sporting events can go. And then what was the second one?
There is also a restriction on fireworks. I should mention, actually, with respect to that the Department of Health issued a guidance on July 2nd, 2020, interim guidance for 4th of July observance and celebration that specifically talks about Department of Health restrictions on these types of events. There's reference in there to fireworks, and now this new executive order expressly states that it's a violation to have fireworks for reasons related to the pandemic.
I just don't know the language of 20247, so it actually says that the whole state is not allowed to have fireworks tomorrow evening? Is
That's
that what
it says?
Oh, wow. Okay. I didn't know that. Okay. And then you said there's a general
Let me
deal,
find it.
which
I think just to be clear, Commissioner, it doesn't say I think they're talking about firework displays for the public.
Correct.
Gary, if you don't have the language, I have it here.
Okay.
I'm fumbling through my papers for it, but go ahead, Tom, if you have it.
Okay, it says the use of fireworks or dangerous fireworks during a state disaster emergency declared by Executive Order 202 shall be punishable as a violation of the public health law. It also says that the use of fireworks by a licensee of any state entity inconsistent with any applicable guidance issued by the Department of Health shall be a basis for suspension or revocation of such license.
Okay. But that's only if they've used it. We can't revoke before they use it, right? That's if
We're not revoking here.
Just on the fireworks.
Well, but understand the relief we're
Okay.
requesting is not to revoke their license. We're asking that a summary suspension be imposed because of an imminent risk of further violations of the law. So you would be within your right to do that, even though they have not used the fireworks.
Okay, got it. And then the third thing was the general EO where we're just not supposed to be in gatherings of more than 10 people. Is that still where we are at, or 50 people?
It was 10 people initially, and based on the phase that each region has reached, that number has gone up. This licensee is in a region that's in phase 4, and the number is 50.
Yes, okay, that's what I thought. Okay, phase 4. Has the governor decided whether Speedway is even part of phase 4? Because I know that just from my own work, like theater and a lot of entertainment are not even in phase 4. And so what's your take on that?
The answer is the executive orders state that these facilities can be open, but not with public spectators. And this is an event that's designed to invite public spectators. That's why it's a violation.
Got it.
So there can be racing in New York State as long as only essential personnel are there. That's
Right.
not what this is.
Right. And so his injunction was denied today. Is that why in the morning he was saying that he thought it applied, and then later he?
No, his lawyer is lying to us. That is my impression. The lawyer told us that he believes this applies when he himself went to get it expanded and failed.
Oh, interesting.
And
he didn't tell you.
Gary, if I could ask a question here, the lawyer sent the decision by Judge Sharp to us to justify his position, correct?
Correct.
Did he also direct you to the most recent note decision by Judge Sharp that actually involved him personally?
He did not do that, and he did not do that. Whether I know he's seen it or not, I don't. Certainly, I would expect he would check to see if there was a ruling on this before he sent me an order that he knows does not apply to his own client. Either way, there's nothing in that order that permits him to violate the executive order. If his executive order, if his interpretation order will apply, not only would every racetrack be able to open, but every movie theater, every concert venue. In fact, no restrictions in the executive orders would apply during July 4th. It would be a complete free-for-all in New York State.
Right.
The notion is simply absurd. If you read the decision of the court, very finely tailored, it came to the conclusion that there were special additional restrictions that applied only to religious services inside and outside. And because there were other types of businesses that did not have the same services, the court found that crossed the line on a First Amendment right to the free exercise of religion. That is the only basis, and it's a temporary order, and it's the only basis on which there's any injunction against any executive order that I'm aware of.
Yeah, no, I understand that. I was just trying to point out that for whatever reason, I would assume also that he saw Judge Sharp's note decision, and for whatever reason, he decided not to forward it.
I think that's a fair assumption. That's a fair assumption of what happened. But even if he didn't know about that, he certainly didn't tell us that he sought to have it expanded and that was pending. He just ignored the fact, perhaps hoping that we wouldn't know.
Did the order come out yesterday or today?
The order, the note order,
yes,
was issued. Hold on. It was issued on July 1st.
Oh my God!
I do not know the date that it was posted.
Okay, but in theory,
it might have been posted on the 2nd, and it might have been posted today. I don't know.
I got it. I understand. Okay. And tell me again, he said that the licensee, Mr. Commander, said that he was told by an elected official that he could open?
That's what Commander told our enforcement guy. But he also told our enforcement guy that his lawyer would explain to us why he was entitled to open. And the only thing the lawyer sent us was a reference to this decision, which he then selectively quotes in a very misleading way.
Right.
So apparently the lawyer wasn't backing up his story that he was told by some elected, or that the Trump administration had made some kind of motion. Neither of those stories were supported by his own lawyer.
Okay.
He said he had support of Congresswoman Elise Stefanik. Is that what you said earlier, Gary?
That is, I am repeating what he told our investigator. I do not know if that happened or not.
Okay, yeah.
But in spite of that, and in spite of him saying that, he was told that he was still violating the executive order and that he risked having his license suspended if he did so, and his response to that was, then suspend my license, essentially.
Okay. I just find it odd because that he would mention her because Columbia County is not in her district. The other thing about the fireworks, you said fireworks for the public are still restricted. That's not private, but public gatherings that have fireworks is still restricted. Is that correct?
I don't know that I know the answer to that. All I know is what the language of the executive order says, and that is that if there's a violation of the fireworks restrictions from the Department of Health, then a licensee of any state entity, use of fireworks by a licensee of any state entity inconsistent with any applicable guidance from the Department of Health shall be a basis for suspension or revocation of the license.
Got it. Okay. I don't have any more questions.
Chairman Bradley? Any questions?
No, I think that they covered them all. Thanks.
All right, then, if we're ready to vote, Commissioner Fan?
It saddens me that some of these licensees are using this whole situation as a political statement and putting, their own health and their employees' health and their patrons' health at risk. And so for Mr. Commander's lack of judgment here, I'm going to vote to summarily suspend his license at the West Lebanon Speedway for imminent threat to public health, welfare, and safety.
Commissioner Ford?
For all the same reasons, I'm going to vote to summarily suspend the license as well. It's obvious he intends on having this event, even though he's been warned about it, and it's almost like he's thrown it down as a challenge. So challenge accepted. I vote to suspend.
Chairman Bradley?
I'm going to vote to suspend as well. While it's somewhat unique that we're actually going to shut a establishment prospectively because of what they say they're going to do, I think the threat here, the public health and safety is obvious, and the licensee as well as his attorney have both made it clear that they are going to go on with this, whether we agree with them or not. And I think that the risk to the public health, particularly in the situation we're in right now, and watching the rest of the country's situation get worse, means that this has to be done before this event can occur.
All right, then. I've got nothing else. Chairman, do you have anything else?
No. But everybody should watch their email, I think, because we may have another one shortly.
All right,
Okay.
then. With that, the meeting is adjourned.
All right, thanks,
Thank
everyone.
you.